Hello, everyone. My name is Corina Weigl, and I'm co-lead of our National Private Client Services Group here at Fasken. I'm also a partner in the Trusts, Wills, Estates, and Charities Group. Thank you for joining us today in our two-part webinar presented by our Private Client Services Group, or PCS for short. PCS is a collaborative practice model bringing together the twin core areas typically needed by clients engaged in estate planning: the Trusts, Wills, Estates, and Charity Group, coupled with our private client expertise. We also draw on other specialized experts in the firm to fully round out our clients' needs. I'm going to be the moderator of today's session, which we have called Hindsight plus Insight equals Foresight. The global pandemic of 2020 has hastened the growth of the virtual world in which we are all increasingly working and living. Aspects of estate and succession planning have become even more top of mind and essential. Over the course of the next 90 minutes, our overall goal is to share with you the general implications we have learned from COVID, together with our own insights into where those implications may have relevance to you, your family, your businesses, and your family office, so that you will have some takeaway knowledge to give you the foresight to think about how those matters may resonate for you. During the first 45 minutes, we will focus on topics relevant to individuals and their families. Then we'll take a short break. Our second session will start at 1, and we will focus on topics relevant to private companies and family offices. As I said, in this first 45-minute session, my colleagues, Demetre, Vasilounis, Tamar, Silverbrook, and Maureen will focus on 3 specific topics that we have seen have had and will continue to have implications for individuals and their families. Both Demetre and Tamar are associates in the Trusts, Wills, Estates, and Charity Group, and Maureen is one of the partners. It's safe to say that COVID has required many changes in how all of us conduct our day-to-day lives and our work. The environments have changed. For many of us, our homes have become our working environments. We are buying groceries online in record numbers. Most of us will undoubtedly do much of our holiday shopping online. Most of us have various online accounts that are financially related and socially related. Pads of paper, pens, and files have been replaced with multiple screens, laptops, and tablets. For our estate planning practice, where original documents like wills and powers of attorney are of paramount importance and still require formal witnessing processes, the need to maintain physical distancing and avoid contact has posed challenges. While the concept of digital assets as part of estate planning has been on the radar for years, the virtual overnight shift to a fully digital life brought on by COVID has now made planning for digital assets more paramount. Demetre is going to lead us through the implications of those assets to your planning. In terms of incapacity planning, I think it's fair to say that prior to COVID, advisors would always ensure that they address the needs for powers of attorney for property and for personal care with their clients. However, whether they had detailed discussions with their clients about decisions related to medical treatment, that was likely not the norm. Since COVID, the importance of expressing your wishes about certain medical treatment decisions has taken on greater importance. Listen to Tamar as she addresses the need to think about incapacity planning. Finally, there's no doubt that COVID has had and will continue to have an economic impact on all of us. The extent of that impact is unlikely to be truly known for some time. One implication is its effect on the timing of transactions you might engage in. Maureen is going to discuss how market forces are a relevant consideration to when you may want to engage in certain types of transactions for your estate plan. In terms of questions, there is a Q&A pane where you can pose them. I am going to be monitoring those questions, and then I will pose them to the speaker at the end of each of their talks. I may in fact pose one of my own. Next. Before turning it over to Demetre, and given the timing of our session is coinciding with thinking about year-end planning, next, I wanted to take this opportunity to remind you of a rule coming into effect in January of next year. Because if that rule has implications to you, you may want to take some steps before the end of 2021. The rule I am speaking about is the new trust reporting rules under the Income Tax Act that will apply to most express trusts, as I've said, starting in 2021. It used to be the case that trusts had a very nominal filing obligation where they didn't have any income to report. In fact, they didn't necessarily need to file a tax return, or they would file a nil return. Starting in 2021, that's no longer going to be the case. Even if trusts have no income to report, there is going to be a whole host of information that is going to need to be disclosed to CRA. Specifically, the information is going to relate to the name, address, date of birth, tax identification number, and jurisdiction of residence of the settlor who created trust, the trustees of your trust, and the beneficiaries who are all ascertained, which could be a fairly large group depending on the trust, as well as persons who can exert influence over trustee decisions. We call those persons protectors. The upshot is, if you've got trusts in your structure that historically have had no obligation to file a return because they didn't have income earned, maybe they just owned private company shares, that's all going to change starting in 2021. Your trustees and your advisors are going to need to take steps to gather the information related to all those different categories of persons. Depending on the size of beneficiary class and the relationships you have with your beneficiaries, that may be difficult to gather up. The upshot is that starting in 2021, the privacy that trusts typically enjoyed from a tax compliant perspective is no longer going to be possible. We think it's safe to say that this is going to increase the administrative burden for trustees, and their record keeping is likely going to need to be enhanced. So if you've got trusts in your structure, this is a good time to step back and look at whether they are continuing to serve their purpose. If they're not, or they're otherwise redundant, you may want to take steps with your advisors. And of course, we're here to help if you want to reach out to us to see if this is a good time to perhaps wind them up or see whether they are still in fact serving their purpose. And so with that, I'm going to pass things over to Demetre to lead us in a discussion about digital assets.
Thank you so much, Corina. Can everyone hear me? Just give me a thumbs up. Yep, great. I'm presenting on digital assets today, and the title of my presentation is Delete Forever, the Legal Challenges of Digital Assets in Estate Planning. So in today's presentation on digital assets, I'm going to hit kind of four main areas. The first is, what are digital assets? The second is, what are the challenges that people have faced in digital asset administration? The third is, what are the relevant laws? And the fourth is, how can I manage my own digital assets in my estate planning? Next. So what are digital assets? I thought it would be interesting to start with the formal definitions crafted by the Uniform Law Conference of Canada and the Uniform Law Commission. So these are both similar bodies, and they've attempted to create laws to kind of to bridge the gap that is currently exists in our law with respect to digital assets. So I thought it was interesting to start with the formal definition, and then we can kind of see what that looks like practically. So according to the Uniform Law Conference of Canada, digital asset means a record that is created, recorded, transmitted, or stored in digital or other intangible form by electronic, magnetic, or optical means, or by any other similar means. Similarly, but with a little bit of a difference, the Uniform Law Commission in the US has defined it as an electronic record in which an individual has a right or interest. The term does not include an underlying asset or liability unless the asset or liability itself is an electronic record. So those are the legal definitions. What does that actually look like practically? Next. Practically, I would say that looks like online accounts. So your email accounts, social media, file storage and sharing, gaming, streaming, all those kinds of online accounts. If you own a website, then the assets associated with the ownership of the website, such as the domain name, any DNS service account, or any other kind of content that you created for the purpose of the website, would be included. Another big one is cryptocurrency and monetary credit. So Bitcoin, Ripple, Ethereum, all those cryptocurrencies, as well as maybe online store credits, rewards programs. If you have even like digital currency in a video game, for example, that would all be included. Another large one is files or content stored on or in association with any of the aforementioned digital assets, including even just your individual email messages, for example. Those could count as files. A license to use any of the above could fall into this definition. Revenue generated from any of the above, of course, like cash is its own asset, but a digital assets clause in a will might very well want to consider the revenue that is generated as the result of a digital asset, because whether or not such revenue can be generated is often dependent on the custodian who facilitates the asset itself. And one thing I would just want everyone to keep in mind too is I think there's a difference between digital assets accessible to you with or without an internet connection. So usually with, there's a digital custodian involved, but without an internet connection, that's something more akin to a file you create on your computer, like a photograph or something along those lines. Next slide, please. So what challenges have people faced in digital estate administration? You know, there are plenty of stories of individuals on the news of people being unable to access relative social media accounts. The classic is the scenario where we have a deceased spouse, and the deceased spouse had maybe an Apple account, an iCloud account, and they were not able to access the photos because of privacy concerns. So there are many stories like that. I don't really have time to go over them all now. And another interesting one in Ontario was an Ontario woman experienced major difficulties in trying to access her deceased son's accounts just to try to find out what had happened to him. So unfortunately, the police had found him deceased at the bottom of Lake Ontario, and he had his phone on him. And the mother was unable to access the phone. She couldn't access any of the accounts on the phone. So the woman experienced a large legal battle just to try to gain access to the accounts the son had on his phone. So there are numerous instances of this, and the consequences could be there could be numerous consequences as well. For example, there could be an inability to access the deceased's email to ascertain what assets they actually have or what assets they actually own, including physical assets. There could be an inability to access a deceased's ownership of a valuable URL as not to be unable to renew the ownership of such URL. And there could just be costly litigation to try to facilitate such access. So the costs certainly are there when there's difficulty in accessing one's digital assets. Next. So the question is, why do people face these challenges, and why is it so difficult just to access somebody's email account after they die? Well, primarily it's because custodians of digital assets do not want to incur liability under privacy legislation. The issue is that absent express consent from the deceased, custodians are reluctant to disclose private personal information. We also have to consider whether or not a deceased person would have wanted their executors to, for example, even see their private messages, see their emails, see private photographs. Jurisdiction is also a key factor as to why this is challenging. Custodians usually want a court order from their home jurisdiction. In many cases, this is California, to better protect themselves. And in fact, in many of the terms and services agreements that these custodians have, the agreements explicitly state that the jurisdiction of California or whichever jurisdiction applies to the agreement that the user has with the custodian for the account. Next. So now that we've looked at the challenges, let's look at the relevant laws, just from a bird's eye view. The first relevant law I would say is a state's law, and I would go specifically to Section 2 of Ontario's Succession Law Reform Act. That section states that a person may by will devise, bequeath, or dispose of all property, whether acquired before or after making his or her will, to which at the time of his or her death, he or she is entitled either at law or in equity. So I bolded the word property, but the interesting thing, there's no actual definition of property in the Succession Law Reform Act. So I just wanted everyone to keep that in mind. I would also mention too that the common law has established the general principle that the executor of a deceased person's estate steps into the shoes of the testator and can do anything that the testator would have been able to do with their property if they were alive. Presumably this would apply to digital assets, and you would think that a deceased person's executor or trustee would just be able to access their accounts, would have the legal authority to do so. However, there is a challenge to that. Next. The challenge is the Federal Personal Information Protection and Electronic Documents Act, PIPEDA, which applies to Ontario. In that act, it defines the term personal information as information about an identifiable individual. So there's a principle in PIPEDA that states that personal information shall not be used or disclosed for the purposes other than those for which it was collected, except with the consent of the individual or as required by law. Personal information shall be retained only as long as necessary for the fulfillment of these purposes. Next. So the problem is that there's no federal or Ontario law that deals with digital assets in estate administration. And the reason I kind of went through those two statutes is to ask the question, is personal information the same thing as property? The question is really, it's one thing to be okay with giving away your money or your car or your personal belongings or your real estate or whatever in your will. It's another thing to be comfortable with people seeing your private messages, for example, or other kind of private photos. So there really is a tension between the two concepts. I would note that PIPEDA does allow for disclosure without the consent of the person 20 years after the death of the individual, but it's not helpful for an estate administration because very few estate administrations go for 20 years or more. I would also note that British Columbia and Alberta have their own provincial privacy legislation that does address this point. However, Ontario does not have its own privacy legislation, and again, PIPEDA does not actually address the digital assets point. Next. So of course, another relevant consideration is that jurisdiction is a major issue. Digital asset custodians can be resident anywhere in the world, and these custodians may want court orders from both the jurisdiction of the deceased and their own jurisdiction. As I mentioned earlier, each custodian has their own terms and conditions that govern the relationship between the user and the custodian. And in many cases, the user only has a license to own something. So that causes a lot of issues because a digital asset, again, when we're talking about property versus personal information, often it's not like you own the asset, you often own a license to use the asset. That being said, it's not as cut and dry as that. There are also intellectual property considerations. Most of those intersect with the Federal Copyright Act. For example, just in an article that came out maybe a month or two ago, I think the spouse had trouble accessing a manuscript or a novel that her deceased spouse had written that was kind of trapped on his device. So there are, of course, both privacy issues there, but also copyright issues as well in terms of accessing the copyrighted asset being the manuscript. So just something else to consider. Next. So now that we've kind of talked about the law and the challenges and what digital assets are, we should just talk briefly about how can one manage their own digital assets in their estate planning. The first recommendation is to check to see if the digital custodian has a post-death account management feature. Two notable examples I would say are Google's inactive account manager or Facebook's memorialization process and legacy contact process. So those are good examples, but not every custodian has that. So you may also just want to check the terms and conditions or other policy documents on the custodian's website. They may talk about what happens to a user after death. They may talk about whether or not an account can even be assigned or not. So that would be important for any particular digital asset. What I would note is that most custodians usually do have a procedure to permanently delete accounts. Very few, if any, allow for the actual disclosure of the account details. So to solve this problem, there actually are third-party services that assist with digital asset management for estate administration purposes. I can share that at Fasken, we are actually working with some of these services. So if anybody wants any more information, happy to speak about that. And you'll see my contact information in a few slides. And what I would say too, just very briefly, is that the mechanisms with which we're working do not rely on the use of password sharing or passwords, well, password sharing generally. It can be ineffective for numerous reasons. So it's just something I do not recommend. Next. It may also be possible to assist with the state administration by providing a positive consent in the will for the purposes of all privacy legislation of any jurisdiction, including PIPEDA. So that's something we're doing in our own clauses. We're providing consent, of course, making sure that the client is okay and would be comfortable with the release of their personal information on these accounts to their beneficiaries and executors and trustees. But that is something to look into as well when drafting a will. I also think it's important to distinguish between digital assets stored with custodians and those stored on personal devices. So again, looking at the online, offline digital assets. That being said, though, if there are certain accounts of which you would not like to disclose the contents to others, this should be specified somewhere in the estate planning. So if you are a person that kind of wants to distinguish amongst your digital assets, it definitely requires a longer conversation with the estate planning practitioner. Lastly, I would say that Ontario law will hopefully develop in this area, but digital asset management, like other areas of estate planning, requires thought. So we have some kind of proposed laws from those uniform law commissions I outlined at the beginning of this presentation, but there is still a gap. So if you do have any questions about this, please feel free to reach out. Next. And that's it. Thanks everyone for listening. And if anyone has any questions, Corina, if anyone's asked any, please feel free to share.
Thank you, Demetre. I have to say, I find the whole concept of planning for digital assets complicated, and that may be because I'm of a different generation than you, and suspect there may be folks in the audience that are of a similar generation. I also find it fascinating that in a former day, executors would have clearly had access to photos and letters, right? We would have had letters. They would have been sitting in somebody's drawer at their house. Their photo albums would be on the shelf, as I'm looking at a few here in my office. And clearly the executors would have had access to all of those materials in hard copy format. And yet somehow, because it's all electronic, we've gotten to this world where all of it is deemed to be private, and it's really making an executor's job difficult. Is there one bit of advice you can give somebody like me and others in the audience that we can do to really try and ease the administration for our loved ones when the event ultimately happens?
I would again reiterate that to the extent for any individual digital asset, so for example, like a Facebook account, do the procedure, kind of select the legacy content, because that can ensure that at least certain aspects of the account can be distributed. So it will depend on the account. With respect to the will, again, like the issue is consent, and a will is not necessarily consent. So a will should definitely indicate consent for the purposes of PIPEDA or other privacy legislation somewhere. Although that's something that I would imagine the non-practitioners in attendance today would have to discuss with their practitioners in order to put it properly in their wills.
All right, well, thank you very much. Tamar, I think you're up. Shed some light on the importance of incapacity planning.
Good afternoon, everybody. As Corina mentioned, I'll be discussing incapacity planning today. Next slide, please. As a bit of an overview, first I'll give you a little bit of a context, specifically with respect to COVID and the impact that that's had on incapacity planning. Then I'll provide a little bit of a refresher on what powers of attorney are, and then go into details about each of those documents. Next slide, please. To provide a little bit of some context, Statistics Canada projects that by 2026, about 20% of the Canadian population will be over the age of 65. This is particularly important because about a quarter of the population over the age of 85 has some form of dementia and Alzheimer's. So mental incapacity has become a social health and legal challenge that affects a surprising amount of Canadians, particularly the senior population. COVID has changed people's perspective from primarily viewing incapacity planning as an issue for adults, particularly seniors, to an issue for everybody. As incidence of incapacity increases, we see an increase in the use of powers of attorney, and that's how COVID has really impacted this environment. Next slide, please. So powers of attorney, just as a brief refresher of what they are, there are two types, powers of attorney for property and personal care. The document itself is called the power of attorney. Within it, you are appointing a person, your attorney, to act on your behalf. And you are the grantor, and the person you are appointing is the attorney, and that creates an agency relationship. With respect to powers of attorney for property, you're appointing your attorney to have authority to act on your behalf with respect to your property. This includes finances such as investment accounts and real property such as your home. Powers of attorney for personal care, you're appointing your attorney to have the authority to act on your behalf with respect to healthcare decisions. This may be treatment decisions, moving you into a long-term care home, or other personal care needs. Next slide, please. With respect to powers of attorney for personal care, this is particularly where we have seen a lot of clients come to us with questions in the new COVID environment. You can use language in your power of attorney to convey to your attorney your wishes with respect to your treatment. Now remember that a power of attorney for personal care only comes into effect when you lose capacity, if that happens. So as long as you are capable, you are making treatment decisions and healthcare decisions on your own behalf. This language on the slide is an example of language that we may include in a power of attorney to start to express your wishes. And so with that, there are a few things to consider. Firstly, if you have an existing power of attorney for personal care, now's a great time to review the language that's in there, particularly because your perspective on certain treatments may have changed in this COVID environment. For example, in the past, a lot of people included language saying that they would not like to be put on a ventilator, but with COVID treatment, now that perspective may change, and you may want to remove that language from your power of attorney for personal care. In addition, you may want to specify that your wishes as expressed in your power of attorney for personal care are in addition to those wishes that you express to your attorney from time to time. This makes it more clear that you can change your wishes, inform your attorney, and not have to redo your power of attorney for personal care. As the novel virus is going around and treatments are continuing to be explored, this may be particularly helpful. Thirdly, for similar reasons, it may be important for you to specify that it's not your intention to fetter the discretion of your attorney. This way, even if you express something such as, I do not want a ventilator to be used, that may have been an expressed wish at the time that it wasn't known that that's helpful should you come down with COVID. So your attorneys are able to use their discretion to override that to achieve your underlying objectives, which would be if they understood that if you had known that a ventilator would have been helpful, then that is what you want. So giving them discretion is helpful in that context. Lastly, for these reasons and some others, it's important now more than ever to communicate with your attorney and discuss these issues. While this may seem obvious, you want to be careful who you appoint as your attorney, again, so that they can achieve those underlying objectives of what you would want for your treatment. And that ties back to giving them discretion. If you don't appoint an attorney or you don't have a power of attorney for personal care, the Healthcare Consent Act does provide a list, a hierarchical list of who may make those decisions on your behalf, but those persons may not be the persons in reality who you would want making decisions on your behalf. And that's why a power of attorney for personal care is important, particularly in this environment. And one issue that's come up quite a bit is the issue of cross-border issues. So clients sometimes appoint attorneys who don't live locally, let's say in Toronto, and perhaps they are appointing their children who live in the US. With COVID and borders being closed, it's particularly difficult for those children to come to Toronto to attend doctor's appointments, to help you move into a long-term care home, or to deal with any of your personal care needs. As a result, we've seen a lot of clients coming and revising their powers of attorney to appoint new attorneys who are more local. This is something we would generally, for the most part, recommend in any event, but we have seen an increase in this revision as a result of COVID. Next slide, please. Powers of attorney for property. Again, you're appointing someone to have authority over your property. That attorney can do anything except make a will. So that means that they also can't change beneficiary designations on your registered policies, such as TFSAs and RRSPs. That's because those policies and beneficiary designations are akin to making a will, and that's why attorneys cannot change those designations. Powers of attorney for property can be springing or not springing, and in this COVID environment, we would particularly recommend that they not be springing, meaning that they're live from the moment that you sign them. A springing power of attorney for property means that a triggering event has to happen for that document to be live, and the attorney to have the authority to act under that or pursuant to that power of attorney. Often that triggering event is your incapacity, and third parties sometimes require proof of that triggering event in order for the attorney to be able to act under the power of attorney. In practice, this may mean that the attorney has to go and get a formal capacity assessment to prove to that third party, for example, a bank, that the triggering event, being your incapacity, has occurred. Capacity assessments can be a lengthy process and very expensive. For example, you may not even be able to get a capacity assessment for a month or two. So having the power of attorney for property effective immediately is effective, particularly in this COVID environment. And some clients are hesitant because that does mean that you're giving authority to your attorney to act immediately. So what we suggest to clients is that Fasken hold on to the original, and that acts as a layer of protection, and that if the attorney contacts us for a copy of the original, we can contact you and we can do a little bit of investigation ourselves without going to that formal capacity assessment. Lastly, on the topic of powers of attorney for property, we suggest, particularly in this COVID environment, that they be continuing powers of attorney for property. So this means that they continue or endure past your incapacity. This is different than powers of attorney for personal care, which are only effective if you become incapable and when you become incapable. These, if they don't have the word continuing power of attorney for property, they actually end if and when you become incapable. And as you can imagine, in this COVID environment, that might not be as helpful as clients would like. So to be a continuing power of attorney for property, as I mentioned, it has to have the word continuing. So continuing power of attorney for property. In addition, the intention of the grantor has to be explicit within the document, saying that they want their attorney to have the ability to act on their behalf past their incapacity. So these are generally the considerations to make, particularly within this COVID environment. There's many others, and you can consider planning tools such as alter ego trusts. However, with respect to COVID and the changes we've seen and clients' interest and focus, those have been in relation to powers of attorney. Thank you.
All right, Tamar, thank you very much for those comments. We do have a question from the audience, and I have a few questions for you, but the question from the audience is, have you come across any examples of ventilators not being provided when a client is diagnosed with COVID because of previous living will instructions? I don't know if you have, or if others on the call with us right now have. Yeah.
No, so I haven't come across this situation, and again, that ties back to my point about wanting to communicate with your attorneys, particularly in this environment, because you can express your wishes to them that you do not wish to be put on, or sorry, that you wish to be put on a ventilator should you come down with COVID, and that would be sufficient in your example.
Yeah, I mean, I haven't either personally, but I do have a good friend whose husband is a doctor at one of the cities in Toronto, and you know, he's talked about situations of this nature where obviously have a previously expressed wish about no ventilator. They have acted on it, but they've also been able to do that by engaging with the individual at the time to confirm that they were their wishes. So one of the other things I wanted to ask you, Tamar, was, you know, people often treat these documents as fairly cursory in the planning phase. And given the decisions about medical treatment are actually extremely difficult, sometimes there's a tendency just to gravitate to your children. Do you ever think it's important to actually have a conversation with clients, to actually have them think about who's going to be the best place to make these difficult choices that will need to be made if the circumstances arise?
Yeah, so I actually recently had a file where most of the time was spent discussing powers of attorney, which is rare. And we had to really discuss who they wanted to appoint, largely because their children were in the States and not able to be local, meaning that they wouldn't be able to go to the hospital if something happened or take them to doctor's appointments or anything like that. So it's not necessary that the children are the best people to appoint. You also need to consider the personalities of your children, and maybe they wouldn't be able to make executive decisions in a stressful situation. So it's a very important and difficult decision to make.
Well, thank you. Thanks very much. And I think with that, we're going to pass it over to we'll pass it over to Maureen to speak to us about timing your transactions. Thanks very much, Tamar.
Thanks, Corina. So today's presentation is going to focus on, it's just going to touch on an estate freeze. Obviously, we could spend a long time talking about the nuances of it, but I want to actually focus on three particular aspects. The first is I'd like to just give an overview about what an estate freeze is. And then in light of the theme of today, which is COVID-related planning issues and the focus on certain planning in light of our current state of affairs, I want to focus particularly on some valuation issues that come about in connection with an estate freeze. And then lastly, I'm going to talk about a variation of a traditional estate freeze, which is a refreeze or a thaw transaction, which people might want to consider in today's world. So what is an estate freeze? An estate freeze is really it's a term of art that applies to a reorganization of a single corporation or a bigger corporate structure that has the effect of fixing the value of the existing common shares at their fair market value at the time of the freeze. You can typically carry it out on a tax-deferred basis under utilizing a number of provisions in the Income Tax Act, Section 85, Section 86, Section 851. And the benefit of a freeze is that the future growth in the corporation itself or the corporate structure accrues on new common shares that are issued as part of the freeze to typically the next generation or in some circumstances, key employees in connection with small business corporations. Next slide, please. The goals of an estate freeze are essentially threefold. The first is to fix and hopefully minimize the tax that arises on the death of the freezer as a result of the deemed disposition on death that will occur. Secondly, it allows, as I mentioned, by having future growth move to the next generation, you're actually also deferring the capital gains tax associated with that growth to the death of the next generation. And the last thing it allows you to do is to do some planning for liquidity on death. By fixing the value of the preferred shares at an amount that is known and doesn't change, it enables the freezor to get his or her affairs in order to perhaps acquire insurance that will fund the tax liability on death, or to come up with another strategy to provide for the necessary funding on death. Those are the tax, next slide, please. Those are the tax considerations, but some of the other considerations that are relevant when you're thinking about whether or not to undertake a freeze, the age and citizenship of the freezer and his or her family is relevant. If there's a US connection, US estate tax considerations will come into play. By freezing the value of the freezer's interest in the corporation, you are in fact freezing the value. And so the income needs and the cash flow requirements of the freezer into the future are relevant. Things like the status of the corporation as a small business corporation impact the planning, the share capital structure, both existing and future, the existence of a shareholders agreement and provisions in it, or the need for a future shareholders agreement. And last but not least, the desire to achieve some protection from claims of ex-spouses on a marriage breakdown. Next slide, please. Why do we care about valuation? And what are the issues associated with valuation? As I mentioned, an estate freeze sets the fair market value of the assets or shares at a particular value, and the gain accrued to that point in time is fixed. What do we need to bear in mind from a valuation perspective? The first and most important thing you need to bear in mind is that the onus of demonstrating or proving value always rests with the taxpayer. If the CRA challenges a valuation approach that's taken, the onus will be on the taxpayer to disprove that. The second thing is that an estate freeze often utilizes what is known as a price adjustment clause. And that is a provision inserted into the share terms that is designed to adjust the value of the freeze shares up or down if there is a change in the value as a result of an assessment, a negotiation with CRA, or the like. CRA has a stated position that it will respect a price adjustment clause, provided, however, that reasonable attempts to do the valuation were undertaken in the first place. So in the absence of those reasonable attempts, there is a risk that your price adjustment clause isn't respected, with the consequence that you essentially have gotten the value wrong. The risk and implications of getting the value wrong are twofold. Firstly, there are provisions in the Tax Act that can actually undo your tax deferral on the initial transaction if you get the value wrong. If your preferred shares have a value that is less, that your stated value is less than what it actually is, and you have therefore diverted excess value to the common shares, and the common shares are owned by a related person to the freezor, you will trigger a capital gain to the freezor in certain circumstances. In other circumstances, it can result in a benefit assessment. The last point I'd like to make about the valuation is that it should not be stale dated. And there is always a bit of a chicken and an egg issue. It's difficult, particularly in small corporate settings, to undertake a value at a particular point in time. But it is important that the valuation be relatively current to the time you do the transaction. Next, please. What is the standard of care in this kind of a market? There is no requirement to get a formal valuation report. However, as I said, you must take reasonable steps. And positions, evaluators out there are, and I've seen in certain circumstances, actually applying what they would call, what they are describing as a COVID discount. particularly in the context of small business corporations carrying on operating businesses and real estate. So it is, it's more challenging. It goes without saying, it's more challenging to come up with a valuation in today's markets. There's also, the question has also been asked of me in the past, whether or not you can cherry pick. Can you pick a day for doing your freeze transaction where the value is the lowest that it has historically been in a long time? I think the answer to that question is it depends. If it's a marketable security portfolio and you have your documents ready to go and you're ready to undertake the freeze and you happen to pick a day when the value is low, I think that's acceptable. What I don't think you can do is look with the benefit of hindsight and say 6 weeks ago was the best day, I'm going to undertake my freeze or my refreeze transaction now. There are issues with respect to shareholders agreements, and I just want to point out that a shareholders agreement is not binding on a valuation point as far as the CRA is concerned, and there is case law to that effect. And if the shareholder is in the middle of a family separation, extra caution needs to be taken because of the fact that value is being diverted. Value is being diverted to the next generation. And so if there are issues between the freezer and his or her spouse at the time a freeze is going to be undertaking, it's best to exercise extra caution. Next slide, please. Freeze shares. Very quickly, freeze shares should have the following attributes, and all of these attributes are designed to buttress the fact that they are supposed to have a fixed value. They can be voting or non-voting. The CRA doesn't attribute any vote value to the voting or non-voting aspect of the shares. The shares are redeemable and retractable for a fair market value equal to what they were issued for. They're entitled to dividends, and there are different practices out there. My practice is to entitle them to fixed non-cumulative dividends, perhaps up to a cap, perhaps a monthly as opposed to an annual dividend. But I think it's fair to say that if the shares are entitled to discretionary dividends without a cap, you run the risk that you haven't actually frozen your shares. And on dissolution, you're entitled to receive your preference share amount back and nothing more. Now, one aspect of a freeze share attribute, typically in order to buttress the share value, there's also what is known as a non-impairment clause inserted into the share terms. And that clause essentially says that you cannot pay a dividend on the common shares if the effect of paying that dividend would render you unable to pay back the full redemption value of the preferred shares. Our environment now, our economic downturn now has put pressure on those provisions because with a decline in value of the company, it may be rendering corporations unable to pay dividends on common shares when they historically have been able to pay common shares because of the impact of that non-impairment clause. Next slide, please. So we talked about freezes very quickly there. Now I want to talk a little bit about a thaw or refreeze. This is a transaction that is becoming more commonplace, especially during economic downturns. And the reason for that is because your preference shares were frozen, assume they were frozen historically at a value of $10 million. If the fair market value of the shares has declined now to $7 million, and $7 million is enough for the freezer to reap the economic benefits of throughout the balance of his or her lifetime, then it might behoove the freezer to consider exchanging those $10 million of shares for shares that have a value of $7 million today and reduce the death tax liability by that extra $3 million. There's two ways to do it. You can do an exchange of shares, or you can actually do another freeze and the freezer takes back common shares, thereby participating in future growth. Now, you should know that a refreeze or a thaw might sound like it's a little bit too good to be true. The CRA does take the position that as long as the decline in value is not a result of you stripping out assets of the company, so deliberately pushing the value down by stripping out assets, then they won't object to a freeze or a thaw transaction. Next slide, please. So again, refreeze or a thaw, what you're doing you're trying to achieve three benefits. You're trying to reduce the redemption price of the freezor's preference shares. You're allowing now, by doing the refreeze and setting the value at a lower amount, you are allowing the next generation to participate in growth during the corporation's actual recovery back to the original starting point. And in certain circumstances, depending on whether trusts have been utilized, a refreeze transaction may allow you to essentially restart the clock on a new trust with a new 21-year clock. And so we have seen refreeze transactions done in those circumstances as well. Next slide. Who can do them? Well, obviously the initial freezor, if capable, can undertake a freeze or refreeze transaction. The question I have been asked lately is whether or not an attorney for property, to Tamar's point, or trustees of alter ego trusts can actually engage in these transactions. I think it's important to look to the terms of the grantor's will or the terms of an alter ego trust in answering that question. While attorneys for property can generally do anything that the grantor of the attorney for property can do except make a will, I think it would be inappropriate, given the nature of the relationship, for an attorney for property to utilize an attorney for property and do something that contravenes the provisions of a will or is otherwise inconsistent with the provisions of the will. The terms of an alter ego trust should be looked at to see whether or not there are provisions in there that specifically authorize reorganization transactions and the entering into and filing of tax elections. And even if not, there is case law support for the notion that it in certain circumstances, it is the responsible and proper exercise of your fiduciary duties to engage in such a refreeze transaction. Next slide, please. Two value-related tax rules that I would like to draw your attention to just before closing. The first is 75.2, and this is an attribution rule that can have somewhat dire consequences. And I won't go through it in a great amount of detail, but the question is, what does it have to do with valuation? And it has to do with valuation because the CRA's position and case law says that if you do a transaction for fair market value, assuming all of the requirements of this section are met, you are not caught within this super attribution rule. And so the valuation point becomes relevant there. Next slide, please. The very last attribution rule I want to talk to that is valuation related is the corporate attribution rule. This is a bit of a trap, and the valuation, and it's a trap because if it applies, it can impute phantom income. It imputes phantom income based on applying the prescribed rate of interest under the Tax Act on the outstanding amount. And the outstanding amount is the value, again, the fair market value of the property that was transferred to the corporation as part of your reorganization transaction. So that's, I think time is up for me. I did want to, for those of you in the audience who are STEP members and who are interested in reading about some of these freezing and valuation and refreezing issues in a little more detailed manner, I would draw your attention to the STEP guide that was published and sent to members last week on exactly this topic, achieving financial security and refreezing and freezing in these difficult economic times. On that note, I'm going to turn it back over to you, Corina.
Thanks, Maureen, for that whirlwind tour through freezes. It was hugely helpful in the summary fashion that you did it in. One of the questions that I'm always asked is, do I need to try and get this done before the end of a calendar year? And so what's the magic around the end of the calendar year? And is it really something that, folks on the line here might need to pay attention to, if at all?
No, there is no magic. I mean, unlike your comment earlier on the trust reporting rules, which will come into force on January 1st, 2021, there is no magic to when you undertake a freeze or a refreeze transaction or a thaw transaction. Again, depending on what's motivating you, it's really just picking the appropriate time to undertake that transaction, bearing in mind you also have dangers. If you freeze at a value that's too low, if you freeze at a value that's too low, your freezer may not have enough economic wherewithal to support his or her lifestyle through to the end. And it's a sad state of affairs when individuals have frozen too early and have run out of money, to be quite frank.
So our listeners here can go away, carefully read the STEP article, and anybody who's not a STEP member, you'll be able to get that from our website in the next few weeks, well, actually this week. Once they've digested it, they can take the time to go to their advisors or come back to us to help them give some advice about potentially thinking about a freeze or a refreeze.
Yes.
All right. That's great. Thank you to our part one panelists, where the focus was on individuals and their families. We're going to take a short break, and after this short break, we'll come back on at 1, and colleagues from 3 other areas of the firm are going to speak to you about topics that are relevant to your private companies, and to the extent you have a family office, your family offices. Thanks very much. We'll see you shortly. Hello, everyone. Thank you for coming back for this second 45-minute session as our webinar today. My colleagues, Zohar Levy, Dan Fabiano, and Doug Scott are going to focus on 3 topics that we have seen have had or will continue to have implications for private companies or family offices. Zohar is a partner in our litigation department. She's going to spend some time addressing the potential exposure to the unique kinds of liability risks that may arise for your private companies as a result of COVID. Following on to Demetre's presentation, Dan Fabiano, a partner in our privacy group, will address the increased cybersecurity and privacy risks that are now going to be quite commonplace in the context of a virtual, personal, and business world that we all find ourselves in. On this point, I can also share that these risks can have a strategic implication to the manner in which certain types of litigation proceedings are conducted, to the extent that those risks actually pose security threats to family members. Last, but certainly not least, Doug Scott, a partner in our corporate group with particular expertise in private companies and their governance. He and I have worked together on several family enterprise mandates involving succession planning and trust restructuring due to that dreaded 21-year income tax rule. In all of them, governance was either an expressed objective for the mandate, or it was going to be a next step in the evolution of the mandate. Doug is going to spend some time addressing why governance continues to remain an important topic for your private companies and your family offices. And again, the Q&A pane is open, and I will be monitoring that pane to pose questions to our presenters after each of them is completed. And with that, I will hand it over to Zohar.
Thank you, Corina. So as Corina has said, I'm a litigator at Fasken, and I am going to just provide sort of a 50,000-foot overview of some sources of liability for either private companies or your family offices. And then I'll go into some COVID-specific considerations. So by way of overview, there are a bunch of different ways that you can be liable for something. One very common way that people are held liable is in the event that there is a contract and somebody alleges a breach of that contract. And this could be you're making the claim that one of your contractors breached their contract, or someone else is going to claim that you've breached a contract that you've entered into. In either case, liability can flow from a breach of contract. And some of this may seem fairly obvious on its face, but I find it's better to start from the same place so that we all know where we're going. And I'll talk about some ways to potentially limit liability under contract in light of COVID. There's also the ability to be found negligent or found liable in tort. And there are 2, broadly speaking, types of torts. One is negligence, which is where you just make a mistake, and as a result of your mistake, someone gets hurt. And then there's a whole broad category of intentional torts. And intentional torts are any tort where you, on purpose or are reckless as to the treatment of someone else, someone to whom you owe some duty or have some relationship. And as Dan Fabiano talks about privacy, you'll hear there are some specific torts that relate to privacy and to maintaining the privacy of data. So the stuff that he has to say also ties back to this as well. And then there can also be liability that arises from various statutory frameworks. And the one that may come up most often, although hopefully none of these come up at all for any of you, but the one that may come up most often is under the OBCA, the Ontario Business and Corporations Act, or the CBCA, where there's the ability to claim as a minority shareholder, even in a privately held company, that the majority shareholder or controlling shareholder is acting in a way that is oppressive to your interest. And that can also give rise to liability. I don't have anything particularly new to say about statutory liability today, although if those sorts of claims arise, of course, we or any competent counsel would be happy and able to help you with them. But I'm going to focus for today on contract and tort. So moving to the next slide. In the context of contracts, one thing that happened very shortly after COVID-19 hit was a flurry of email traffic and client calls when people wanted to look at the contracts that they had entered into and say, what do I do now? I contracted to rent 30 trucks, but the truck drivers can't go on the road. They can't pick up the things they need to pick up and they can't drop them off and nobody wants to buy them. So now what do I do? And so it's important to look at our contracts now that we have the benefit of being many months into this pandemic and think, Is performance possible? Is it likely to be affected by external factors? And those external factors include shifting governmental regulations. So the on-again, off-again lockdowns in Toronto and other municipal areas are a good example of when a contract may go from impossible to impossible again over a very brief period of time. And some abilities to protect yourself or some considerations when you're entering into new contracts or looking at contracts that you've already entered into to say, what do I do now? Are two clauses that you can think about. One clause in one common law doctrine. So the clause is that you'll most commonly see as a force majeure clause. And in older contracts, it will show up as something like an act of God clause. Basically, if something happens that is outside the control of the parties can agree that one or the other or both of the parties will be discharged from some or all of their obligations indefinitely or for a specific period of time. It basically allows parties, if they turn their mind to not COVID specifically, but in general, to a worst case scenario to say, what do we want to have happen with this contract and with this agreement? And so in my previous example of a truck rental agreement, you may want to say, in the event of a global pandemic where mobility is limited, this contract is suspended until mobility is restored. Now that's very specific to the context that we find ourselves in, and most force majeure clauses are not that specific for good reason, because sitting here this time last year, none of us would have had any idea what was coming down the pipe in 2020. And so the better force majeure clauses are the broader force majeure clauses that are informed by what we've seen in this past while. And so, for example, you may want a force majeure clause that says, if due to disease, government regulation, labor disruption, et cetera, a whole list of different things, performance under this contract becomes impossible, illegal, very difficult, or materially changed, then the obligation to perform is suspended for the duration of that event. That might be a sort of broader contract that you might want to consider. The doctrine of frustration is different from force majeure, and you'll never see the doctrine of frustration incorporated specifically into contracts because it's a common law doctrine. And it basically provides that if the fundamental purpose of the contract can no longer be affected, then the contract is deemed to be at an end. So for example, if I contract to paint a ship and the ship sinks, that contract has been frustrated through no fault of the party, but even if I'm ready, willing, and able to paint that ship, can't get paid for painting it because there's no ship left to paint. That's actually the real and original case that gave rise to the doctrine of frustration. So those are two things to bear in mind when you look at your contracts. But as with so many lawyer answers, and I know that you've already heard that once today, at least once today, may have been more, it's going to depend in terms of your contracts and your specific obligations and the factual matrix that you operate in and your business realities. So all I can say in general in terms of contract considerations, if you're looking at your contracts in this post-COVID world or mid-COVID world, it's a good idea to consider whether or not you want to keep performing, whether or not the other party is able to keep performing, and what you want that to look like, and get legal advice in that regard. Moving on to the next slide. And on to the next potential cause of action. So I'm not going to talk about the intentional tort. Oh, no, sorry, back one. So I'm not going to talk about the intentional torts. I'm going to focus my comments on negligence because the reality is I'm sure that none of you would deliberately go out of your way to harm someone or be reckless as to what your conduct may mean for someone. And so, and even if you were to, that's not particularly tied to COVID. Negligence, on the other hand, can happen anytime. And as you can see from the definition in the PowerPoint slide, negligence arises where the conduct of a party falls below what a reasonable person in the same circumstances would do. So that means, for example, if you're standing at a crosswalk waiting to cross and you step out in front of a moving car, instead of pressing the button, waiting for the light to flash and then walking across once it's safe to do so, you perhaps were negligent and you weren't taking care of your own safety in that regard. In the more specific context of the operation of your own companies and your family offices, even if there is negligence in the operation of those offices, it is possible to avoid that negligence or that a finding of liability for your negligence through a couple of different options. With respect to COVID specifically, there's Bill 218, which I'll get to in a moment, but I'm not there yet. But more generally, as an occupier of, for example, an office building or land in general, you are able to have all entrants to your property sign a waiver. And that waiver allows you to protect yourself from a finding of negligence, because that person who's entering your property says, I agree that by entering this property, there's the potential that the floors may be mopped poorly and I could slip and fall, and I accept that risk, and here I go. I'm going to enter the property anyway. And of course, most waivers, just like most force majeure clauses, are drafted much more broadly than that. But a waiver in general can provide you with protection against claims of negligence. There are a couple exceptions. Minors, generally speaking, minors being under the age of 18, generally speaking, are not capable of waiving their own claims, and nor can anyone waive their claims for them. So parental waivers signed on behalf of minors don't work. Again, there are exceptions, but generally speaking, that is the case. And the other exception in most cases is employees. And specifically, we've seen a lot of our clients who have done COVID-specific waivers, where they've said, look, we want to reopen our offices, we want to reopen our facilities, we want to reopen for business, but we're very worried that if we reopen, we're going to get sued if someone in our facilities contracts COVID. And so I have seen a whole host of waivers that are specifically targeted at COVID-related risks. And these waivers in general are enforceable, we think. I mean, they haven't yet been tried in court, but they would be enforceable for visitors to the property, for example. But employees generally can't waive their protections under the relevant provincial employment standard legislation. So that's another exception to the waiver. So those are some ways to protect yourself from negligence claims. And if we go to the next slide, there's also, for those operating in Ontario, a huge protection for negligence claims with respect to COVID specifically, that has just been enacted by the government and just received royal assent by the provincial government here. And that's Bill 218. And this slide just has the key operative provision of Bill 218, which I will not read out loud to you because people reading from PowerPoint slides is not always the most helpful. But essentially what it stands for is it says that if someone on your facilities gets COVID, they have no cause of action, they can't sue you, as long as you acted or made a good faith effort to act in accordance with public health guidance and federal or provincial law, and that act does not constitute gross negligence. And there's a whole lot to unpack here in terms of what that actually means. So in terms of the public health guidance, that's defined elsewhere in Bill 218. And before we even get there, the good faith effort is also defined in the law, and it means an honest effort, whether or not that effort is reasonable. It's not yet clear what it is that you're going to need to be able to do in order to show an honest effort. But I would suggest that if you're interested in trying to avail yourself of the protections available in Bill 218, one of the best practices that you can do is to generate records, to create a record saying, this is our policy on COVID, and these are the steps that we are taking in compliance with this public health guidance. And having that sort of a statement, I think will certainly meet the standard or requirement that it's an honest effort to act in accordance with the public health guidance. And the definition of public health guidance is also interesting. It refers to guidance from basically every public health source available, provincial, federal, and municipal. And it says that in the event of inconsistencies, it doesn't matter as long as you're following one of their guidances. I'm not sure how this would play out in the context of, for example, if Toronto, and I recognize this is Toronto-centric, but that's just because we get to the benefit of all of the lockdowns. If Toronto had more restrictions being put to it on a municipal level than was imposed on a provincial level, if you abided by the provincial guidelines only, it's not, under a plain language reading of the act, it seems that you would still be okay, but as a common sense matter, it doesn't feel right that that would be so. So it's to be determined what the courts are going to do with that. And then the other concept, just to briefly unpack here, is the idea of gross negligence. And we've talked briefly about negligence as being falling below the standard of care for a reasonably prudent person in the same circumstances. Gross negligence is much more than that. So, you know, if you are negligent to step in front of a speeding car, you would be grossly negligent if, for example, you shone a bright flashlight into the eyes of the driver as the speeding car was approaching you. It's poorly defined in the case law, and it's very difficult to give good examples of it because it's so rarely found, but that's a somewhat facetious example of it. So there's a lot more to Bill 218 than this brief slide and cursory overview would suggest. But in short, my suggestions would be, if you're looking at trying to reopen as safely as possible, given the COVID-19 world, the idea of reopening or continuing to operate is a good one. You may want to consider, to protect yourself, waivers to deal with negligence, record keeping to show that you fall under Bill 218, or if you're outside of Ontario, to show that you're not negligent, that you're acting as a reasonable person would. And with respect to the contracts that you're looking at drafting, consider your force majeure clauses. So those are my 3 takeaways, and I believe that I'm at my time, although Corina will tell me otherwise if that is so.
You are, yeah. Thanks, Zohar. I had one question just on your recommendation about trying to tailor the force majeure clause to really be more specific to the events that businesses are facing right now. I suppose there's going to be a practical element to the ability to actually get that type of clause if you're dealing with 2 parties where one has a higher bargaining power than the other. So whether or not somebody can actually get that nice tailored type of clause to protect them is really going to depending upon who the parties are to the contract, right?
Absolutely. And there will be the contracts of adhesion. So, you know, when you sign your cell phone contract with a major telecom provider, you're not going to be able to turn around to them and say, well, I want a force majeure clause in here that benefits me.
Right.
I mean, and again, in my truck rental example, there are a lot of large rental companies that have their standard rental agreements, and they're not going to change those.
Right.
But if you're dealing with another, often you'll see it when you're dealing with service providers like cleaners who come into your building, that sort of thing, where there's a much more comparable size in terms of the companies negotiating. There's a real ability to put in something tailored.
Right, that's great. Thank you very much.
Thank you.
And so with that, I'm going to ask Dan Fabiano to follow on to Demetre's comments and give us his thoughts on sort of cybersecurity and privacy related risks.
Happy to do so, thank you. Let's jump to the next slide and just dive right in. So 99% of Canadian organizations saw increased cyber attacks over the past 12 months. Now, concerns that were present before the pandemic, so concerns like phishing attempts, hacking, malware, and so forth, they've only been exacerbated by the current context. I mean, there are more ways for criminals to attack and more vulnerabilities for them to exploit. For example, we now rely much more on email in place of in-person or telephone interaction than we did before. We are probably relying on software that we may not have used before, and that lack of familiarity may itself create gaps. Your employees may now be using personal devices for work purposes rather than company devices. You may even have gaps in your policies and procedures and training for employees that just don't cover work from home situations. And this one probably goes without saying, but the COVID pandemic creates a lot of anxiety. And that anxiety also gives new hooks and new sort of social engineering tools in the criminal's toolkit, new reasons for feigned urgency that requires immediate response. And these are things that phishing and similar attacks can readily exploit. So obviously the current environment exposes businesses, but it's important to note it exposes all businesses to significant cybersecurity risks. It's not just the big data-driven businesses. Every business handles confidential information electronically. And so every business is subject to attack and then needs to take cybersecurity seriously. Although this presentation is going to focus on business considerations, cybersecurity is also a concern for private clients personally, as well as their families. I mean, we're all familiar with those, rather annoying automated telephone calls from Revenue Canada claiming that we're going to jail if we don't, call them back and hand over lots of sensitive information that they can use against us. But in the online space, cybercrime can be much more subtle. So some of my comments that are specific to business can be extrapolated and applied to one's personal and family life as well. Next slide. Aside from cybersecurity, working from home and remote working also presents privacy law compliance concerns for businesses. So even as we're challenged by these new working arrangements, by having people working remotely and by trying to make it all kind of hang together and exchange information and so forth, even as we're facing those challenges, our organizations are still subject to privacy laws when they're handling personal information, which includes legal requirements around security safeguards, need to know access restrictions, secure deletion of data, reporting privacy breaches. All that stuff still applies. And failing to meet those obligations can bring legal claims, it can bring privacy commissioner investigations, and can bring resulting reputational and financial harm. So given these privacy compliance concerns and the cybersecurity risks that I quickly overviewed a moment ago, what is it that we can do? What are some tips and some helpful guidance that we could perhaps consider and adopt? Next slide. Whether remote working is a short-term strategy or a long-term investment, companies will need to invest in a range of technology supports, policies, procedures, and training to address the new reality. Now, an exhaustive list of those measures is going to take some time to describe, more time than we have here. But I wanted to highlight some of the items that you or your privacy or technology managers, the folks that run those aspects of your businesses, things that they might want to consider and that you could pass along or that you could consider yourself directly. A good starting point is cyber insurance. Your company may already have it, but in any case, it's worth considering whether work from home presents an increased risk and maybe it's changed your risk exposure and maybe it's time to revisit cyber insurance. This insurance can cover a range of things. It can cover the cost to responding to a cyber incident, which could include paying for IT forensics experts to come in and figure out the cause and help you fix it and close the gaps. It could also cover paying for legal experts to help address legal liability, to help frame how you approach commissioner reports and similar breach reporting obligations that your company might be subject to. And the insurance can also even cover the cost of breach notification. How much you'd have to invest in telling whoever needs to be told about the breach and dealing with their questions. And it can even cover third-party claims from injured parties. So if cyber insurance is not something that your company has invested in or investigated before, but you are working from home, I think now more than ever is a time to investigate and to consider whether it's right for your business. Next. Another threshold item to keep on top of is just the raw IT infrastructure. And that includes critical patches and updates to software, making sure those are installed. That's frankly what so much of cybercrime is about. It's about exploiting the fact that a company wasn't up to date on applying patches and updates to critical software. This is normal course stuff. But given the statistic I cited at the top of my presentation, companies are under attack more than ever. And so it's more important to be on top of these sorts of things. The pandemic is not the time to downplay IT maintenance. And it also might be time to bring in more IT support. The work from home experience is now many months old, and most companies have likely worked out major kinks in how their technology interfaces and how folks work from home and can access that technology. But if you're rolling out new technology from this point on, you're going to need more technical support on hand, more support in the vein of help desks, so that your staff can get those problems resolved and can keep the business running and keep the data secure. Next. This is probably one of the most significant points I'll talk about today. And it's really the question of whether your employees are now using personal devices for company work. So are they using personal devices or company devices when working remotely? The reason why this is significant is that personal devices more easily offer gaps in your company's security profile, possibly because it's more likely that they'll be exposed to malware, because simply they're used not only for business purposes, but also for personal purposes. Those personal devices may not be suitably protected. They may not have the right antivirus and similar defenses in place to protect the computer. And they may even use weak passwords or no passwords to log in and to access the software. So if your employees are using personal devices to perform work, then you should consider a few things. First, consider providing them with company devices. Even letting them take home their office desktops might be a decent workaround. If, however, it's necessary that the employees continue to use those personal devices, then revisit or consider what sort of secure software or apps can be deployed. I mean, can you force the employees to use those personal devices to then, through a virtual private network or similar solution, dial into work so that as they're working, they're still working on your servers, even as they're accessing those servers from personal devices? What software can you deploy to make those personal devices more secure? Personal devices, though, are of particular concern if employees are using them to store sensitive data, which would include personal information about clients or about other employees. If that's happening, that is highly problematic for them to use personal devices. It creates privacy law compliance issues if personal information is not stored on company-controlled computers or devices. So that's something you would very much want to address. And it may mean that your employees have to only store information on company servers and have to dial in remotely to access it, nothing being stored locally. Given all this, if employees are using personal devices, you should consider whether you have the right policies in place. Sometimes it's called a bring your own device, BYOD policy. But the goal is to put a document in front of your employees to help explain to them what's expected of them and the risks and concerns around them using those personal devices to handle company data. So if you don't have a BYOD policy in place and you're allowing your employees to use personal devices, you very much need such a policy. Next. This one is probably a given, but it's worth mentioning given how common it is as a stumbling block. If employees are logging into work accounts from home, is your company using multi-factor authentication? So for those of you who may not be familiar with what I mean, this is commonly manifested in a dongle, like a little, a small sort of thing that gets attached to your keys, or a smartphone app. It generates a rotating number. And so the idea is when you want to log into a system, you've got your username, you've got your password, but then you also have to enter in whatever the current number is on that dongle or on that app. And that's just an extra layer of security because a criminal doesn't have access to that number. And so multi-factor authentication helps guard against the fact that a criminal might have somehow got a hold of your username and password, but will never know what that rotating number is. I say all of this, and it is a given, but I say all of this because an inability to institute this sort of authentication process has been reported as the biggest threat to businesses during COVID-19. Companies were simply not able to roll it out or failed to roll it out fast enough. And it created a significant gap where criminals could exploit. And also, aside from just sort of a cybersecurity concern, lack of multi-factor authentication is often cited as a major flaw by privacy commissioners when they investigate companies due to privacy breaches. And they inevitably uncover a failure to deploy multi-factor authentication. So if you're not deploying it, it's worthwhile having your IT leads investigate this and to get it deployed as quickly as possible. Next. This one is somewhat variable, but if employees are accessing sensitive data, and I don't just mean personal information, but just sensitive data that they're handling in the course of their day, and they're working from home, it may be useful to understand or to have some members of your team understand what is their home working environment. This can vary radically from person to person. And so, where are they within their home? Who's around? How are they handling materials as part of their workday? And it may seem odd, but one thing that might be an option would be to have employees take a photo of their work from home environment or diagram it or describe it somehow so that your team can actually review it on a case-by-case basis and figure out for each employee maybe what suggestions around security might be useful. So for example, your screen is beside the window of a street. People can see what's on your screen, or even other people in your house are coming in and out and they can see what you're doing, and that's just inappropriate. You should maybe rearrange how your desk works or rearrange where your screen is placed. That's an easy example. Another example might be if information is particularly sensitive, are we dealing with locked cabinets for paper records, that kind of thing. In fact, is even printing or creating paper records something that you want to allow? Because then it creates that issue of how are you storing those records, and when those records are no longer needed, how are they being disposed of in a secure way? How does that all play out for a given home office? So it's important to sort of take stock of that for each of your employees, particularly where they're handling sensitive data, so that you can help them do a better job of protecting your company's information. Next slide. I won't spend much time on this, but the key concern on data backup is just making sure that if employees are storing data at home, how does that fit into your overall backup strategy? If they were at the office and working on work computers, presumably their data would be caught up in your normal backup systems that are backing up your data in the event of some kind of business interruption event. How does that play out when they're working from home? And is that data being backed up? Next. And this is probably the big item here, which is cybersecurity training. When were your personnel last trained on cybersecurity? Lack of this sort of training is a major flaw that has been cited by privacy commissioners. In fact, this even goes to family members. Have you coached your family members on cybersecurity? If they create a gap in your cyber armor, so to speak, how could that play out in terms of your company or your personal reputation, or could it even play out in an even more serious way? I mean, everyone clicks on phishing emails from time to time. I shouldn't say everyone, but inevitably some phishing email will entice someone to click on it. And once people are working outside their normal environments, maybe on edge, maybe a little uncertain as to what's going on, as I said earlier, they're vulnerable in a new way. And so criminals are trying to take advantage of that. Next. If a cyber event occurs, does your company have a plan? And I won't go through each of the items in the course of the next few bullets. I'll let you read them as I speak. But basically, the idea is in order to prepare for a cyber event and to respond to it effectively, it needs a documented plan as to how it's going to unfold, as to who are the core team members that need to be contacted, how do you get a hold of them, which could include personal cell numbers and so forth, because cyber events tend to occur at off hours. What are some external resources, legal or otherwise, that can help you, and so forth. Planning this out and mapping it is key to an effective response. And one point I'll mention here is, and on the next slide, if you would, is the notion of legal privilege. The idea is to respond to a data breach with a litigation mindset. And the reason is because all of the records arising out of a breach investigation are discoverable by other parties unless you can assert solicitor-client privilege over those records. So having legal counsel at the center of a breach response is critical to being able to put yourself in the best position of asserting privilege over those sensitive documents. And maybe just one word on the end. There's no point in having a protocol if employees don't understand it. So prior training for employees, or even a test run around how the protocol works, is effective in ensuring that your company is able to respond to a cybersecurity event quickly, to have the right people on board, and to minimize your liability going forward. That's all I wanted to say for today, but I'm happy to entertain any questions that you might have.
Thanks, Dan. That was hugely insightful. And you're absolutely right. Everybody from time to time gets caught by a phishing scam, including myself. I happened to get one of those telephone calls where it was ostensibly CIBC calling to find or provide some information about where my credit balance was. And I actually got so far as having given the person my SIN number. And then they continued to ask me questions, and I realized, well, I don't have this information. I have to bring my husband on the call, and that's when the phone went dead. So, and at that moment I thought, oh, that was one of those calls, and I was duped. And I consider myself to be fairly astute. So anybody, I think, can be subject to one of those scams. You talked about how family offices and family members need to pay attention to these types of things from a cybersecurity perspective, because there can be chinks in the armor that are brought on by family members themselves. And I know the family offices I work with, the security of their family members, the wealth information about family members, and the family reputation itself is of critical importance. Is there any sort of one or two short messages you can convey in terms of what family offices can do to educate the next generation about social media usage? Because I think that becomes a dangerous tool in itself from time to time.
Sure, and social media usage can also be can also be leveraged to target these phishing attacks that I mentioned earlier. I mean, the reality is that if family members, if any of us overshare our personal information online, it creates opportunities that criminals can leverage. Everything from location information, where you live, or the fact that you're on vacation and so not at home, images of yourself, images of family property, even status updates. All of this information can assist criminals in identifying high-value targets, in locating where those targets are, or otherwise giving them information that they can exploit to get close to targets and to cause harm. So just as any company would want to train its employees on cybersecurity matters and on what to look out for and when it comes to phishing and similar things, I think a family office should also look and consider how to train family members, both on the social media aspect, so the not oversharing, to being very judicious about what is posted, but also to be wary about what might come in over email, and what sort of links are being clicked and what sort of information is being divulged in response to requests. I think educating family members on this caution is a critical part to making sure that they don't end up inadvertently helping criminals harm the business or the wealth of the family or its reputation, or even physically harm individual family members. It all kind of bundles together.
That's great. Thanks so much for your insightful comments this afternoon. And with that, I'm going to pass it over to our last speaker of this two-part webinar. Doug Scott is going to share with us his thoughts on governance.
Thank you, Corina. This session, this last session today, will focus on family enterprise governance and the rising interest in it. And we're going to look at some themes from 2020 and see if we can't help you plan for the future. So first of all, we're working in the space between what I'll call family or family groups, investors, and the business itself. Next slide, please. Let's see what the experts say. So often, if anyone involved in family governance, you look it up and you'll see statements like families who successfully manage and preserve wealth through generations tend to do things differently. And one of the things that they do in common is they acknowledge the need to establish a framework of decision-making that's documented and communicated. And that's what we're going today call governance. It's quite broad. Next. Corporate governance, we all know about corporate governance. That's the standards for board composition, boards and shareholder meetings, duties, independence, the disclosure requirements for public companies. We're all well versed in that. There's lots in the media. When it comes to family enterprise, though, we all know that it's very different. There is, however, a little bit of a framework, but not much. And when I mean the framework on the corporate statute side. So next, please. So essentially that leaves you with good things in the sense that you have freedom to choose. You have less regulation, but that can, on the downside, mean that you have less guidance and there's less of a framework within which to work. Next. So I'm going to look at the current state of affairs, what we've learned in 2020, what we've experienced in 2020, what's changed, and what families have learned from it, what we see families doing. Next. I'm going to look at some developing themes, some growing trends, and as I said, what family enterprises are doing to adopt or address these themes and trends. Next. COVID-19, of course, is one of them. I'm going to try to connect some dots for you. And also back to what we've just been discussing today, but bring it into the corporate world and the ownership world. Look at increased requirements for ownership transparency and the loss of privacy and what action that is causing people to take. Next. There's a realization, this is my COVID-19 screen, it's going to be the only one on COVID-19, but the theme's going to come up again. So there's been a realization and acceptance, I think, that things may not come back to where they were before. There's certainly stability, uncertainty, there's doubt in the world. There's an acknowledgement of the unpredictability of life and of business operations. Some of our clients have been relatively unscathed. Others have been hit very, very hard through what's happened. This, of course, as I said earlier, is translating into family and government, or sorry, corporate action. There's been government action, but of course, corporate action as well. So we're going to look at what some of that action is. Next slide, please. Within transparency, as I mentioned earlier, securities laws, they are always changing worldwide. So families with significant public holdings are now faced with greater disclosure obligations. Boards have always, and significant or C-suite, people have always been used to this, but shareholder ownership, large stakes are increasingly being subjected to developing securities laws and transparency registers. So things that have been developing in Europe for years in terms of anti-money laundering are now finding their way into certain jurisdictions, legislation in Canada. A lot of this is not necessarily public, but there is a concern of a loss of privacy. And this, of course, can lead, as Corina was referencing earlier, to personal security concerns as well. So there are steps that can be taken to address this on the corporate side. Next. There's certainly a heightened sense of a need to take control and own your own destiny. There's a need for a plan, and people are saying we're going back and we're now rethinking about the way we have things structured and how it's all documented and communicated. Next. That need for a plan is really where the governance comes in. As I say, when we get into family governance or family enterprise governance, it's a very broad spectrum. It's much broader than the pure corporate world and certainly broader than the public company world. And now I just want to ask, so what are the themes in 2020 that we've seen within family enterprise governance? Well, next. The buzzwords this year, they haven't been all corporate words. They've been more family words. They've been things such as value and family culture, mission, family alignment towards the mission, mentorship, that's a recurring theme, has been for years, for generations, but it's coming up in a different way this year. Preservation, another constant theme, but now people are speaking about legacy and be it personal and family goals for the family that they might want to see instilled. Next. There's certainly a growing focus on communication. So it's not a matter of holding the information back from family until the very last moment, but early education, early communication, and striving for a common understanding of the roles and responsibilities within family. And that doesn't just mean roles of responsibilities if you're running the business. That can mean roles and responsibilities just as a family member or as a shareholder, as somebody who holds a part of that wealth and may not even be involved in the business in any way, in any active way. Mentoring, of course, the next generation, as I said earlier, a constant theme, but now probably a greater shift we're seeing towards getting professional assistance towards for mentoring, and abandoning what I've said here in the slide, the DIY, the do-it-yourself approach. New word we've seen a lot this year that's being put into action is gratitude. People who are truly thankful, those who haven't been so affected, are truly thankful for that. And now they're thinking about, well, but it could have been me. So they're thinking of the legacy and the need to protect that legacy and to pass on the information and instill the sense of legacy in future generations, and maybe pass on the need, if that's how they feel, maybe that's really a custodial obligation that they want others to have as well. So how are families next? Sorry, you're good, slide person. Next, stay here. How are family enterprises putting these trends into action? So 4 things I'm going to look at for the balance of this presentation. Family values and mission statements, the formalization of the family council, the growth of family offices, the continued growth of family offices in Canada, and the re-engineering of the shareholder agreement, or what we call the family agreement. Next. So family values and mission statements. These, of course, every family has their own name for it: the game book, the rule book, the guidebook, the family Bible. Often it's the first step in family governance, and although not a legal document, I view them as very, very good documents, because this is really where you start to set your family values out and communicate them. Next. So this document, which I said again can be quite casual. It doesn't need to be in legal language, although there can be legal aspects to it. It can cover, as the top of the slide says, governance issues such as who's going to do what and what are the roles and responsibilities, professional roles and responsibilities. But you also get into more values-focused issues. So bottom of the slide, expectations, even charitable endeavors, and what the expectations for that would be. Next. Family councils. Family councils, of course, have been around forever. The first family council was probably the family dinner held on a Friday, Saturday, or Sunday night. Those, of course, persist, and that is the model for the informal family council. But of course, these are becoming more formalized. And the family dinner is that first line up on the slide, the information sharing amongst family members. But now, formalized family councils allow you to evaluate issues in a more formalized structure and elevate wishes to the board. So if you have a more professional board, which might have some family representation, but might not be made up entirely of family, and certainly not all the family members who might be owners, family members that I referenced earlier who might not be involved in the day-to-day business are looking for an avenue to bring that information or have it surfaced and brought to the board, but in an organized fashion. You can't have a board with 12 different people telling them what they want just because they happen to own the company. So the family council, of course, can act as really a critical avenue for communication. There's always an element of preparation of the next generation in family councils and even leader identification. Next. Family offices, of course, are the professionalized buffer between the family and the family enterprise. They maintain the distance and the separation from operations, really reduce that stress on operational resources where they can. Of course, it's not for everybody. There are costs associated with family offices, but as I say, it's a growing trend in Canada. It's been used in Europe and the States much more prevalently, I guess, than in Canada, but is now seen and is much more common in Canada. And of course, it can be just a service provider sometimes. So it's providing that estate planning, tax planning, legal services, cash management for the family, but can also be used and is now more often used for family as a family investment vehicle. Next. So this all sounds like a lot. And the question we're often asked is that second item on the slide, and that is, well, can this be consolidated or simplified? All these different aspects that you're speaking of. And our answer is yes. At the top of the slide, you'll see the reference to the family shareholders agreement. And really, we've been pulling these things together, and this is what families do. They pull them together in a shareholders agreement, covering those technical aspects of owning shares in a family enterprise, but really working to bring in a lot of the family values and the vision and the mission into that legally binding document that really reflects the heart and soul of the family. So it's not just a corporate document. Next slide. So what makes, or how do you achieve that? How do you have a shareholders agreement that really speaks about all those technical things and yet reflects the family? Well, it often starts with a framework. So you will see things such as I've written here, preserving and protecting family unity. And it's uncanny how often You think that the shareholder agreement is going to be about those technical things, about ownership and voting rights and who's on the board. And yes, it's in there. But the first thing is often family unity. And that statement will find its way into many shareholder agreements or family agreements. It's not just in the mission statement, it's imported. Then you talk about preserving wealth and establishing common understanding so that families can plan for their lives. And I'm going to get into that aspect a little later in the talk. Next slide, please. So shareholder agreements, of course, typically many of you would have shareholder agreements, or you might have co-invested with other families, other investors. You have joint venture agreements, partnership agreements. Shareholder agreements, they cover governance, they cover money, who's obligated to fund, what are the right to share in profits, or the rights to share in profits, how can you get in, get out. All of that can be in a family enterprise agreement, in a shareholder agreement, but it's handled very differently. Next slide, please. So a good family agreement, as I said earlier, covers all those technical aspects, but it has that mission, vision, and values in it. Next. And now for the last session, or last part of this session, I'm going to just do a rapid fire round of governance in the context of the family enterprise, and specifically in this thing we call the family agreement. So the first thing, so what's in there? As I said earlier, what's in there? Well, first thing is there's an attention to multi-generational or even multi-family rights and entitlements. So moving from parents down to children, might be 2, 3, 5. A good agreement will try to bridge that or deal with that gap. It might be at the level of the 2, 3, or 5 and moving into the next generation, the 12, the 16, the 20. Governance in a family agreement should really mature as the family grows. Now, a shareholder agreement itself, without trust structures on top of it, etc., can't really run for multiple generations. You hear about European families, they're into the 12th generation or the 20th generation. That's difficult to do on its own within the shareholder agreement or family agreement. But a good agreement is at least going to get you forward into the next generation and maybe give some guidance to generations after that. Next. Board composition, of course, is going to be covered. How is board composition going to be determined? Are there blood entitlements? So anyone who's a lineal descendant of the founder, are they entitled to board participation? Well, that's harder as you get into successive generations, but are there going to be entitlements, at least in terms of nomination, since you are a shareholder? Are there going to be blood requirements? Can it only be blood members, lineal descendants who are going to be on the board, or are you going to allow for independence? Next slide. Independence. How are they going to be chosen? Who has the nomination rights? Next slides. Actually, we can pause there and just independence, another growing trend. Looking for outside professional help at the board level. That is common, of course, at the operations level. So day-to-day operations, president, vice presidents, head of HR, non-family members, absolutely. At the board, within family enterprises, we're seeing more and more seeking to go out and find outside help at the board, really at the vision level, and having assistance. So we're now on the next slide. Shareholder meetings and decision-making. Of course, that's got to be covered in any shareholder agreement, standard shareholder agreement with your third parties. But within the family, again, it's going to be a little bit different. You start to get into issues such as, will the founder have a veto? And what if the founder has a veto? What happens if there's an incapacity? How are we going to deal with that? Does it, if you're just on a board and incapacitated, well, that usually would knock you out. Well, within family agreements, the founder might have views as to who is going to step in, and you could provide for that in the agreement. Next slide. Proxy rights. Funny thing to talk about in a family agreement, but believe me, it does come up. Shareholder agreements, we think of That leads to shareholder meetings. Well, shareholder meetings, shareholders show up. Shareholders can't attend. A shareholder's out of town, is a family member, can send a proxy. Can that be anybody? Can you send your lawyer? This is a family company. A lot of families feel this is a family company. We don't want lawyers around the table. We want family members. So maybe proxies should only be going to other family members. If you have multiple branches, does it need to stay within a branch? Can it be any family member? Next. We've spoken about institutionalizing and codifying family council and family office. Just here, often your shareholder agreement will really have to reference the existence of these. So again, so that they're not operating separately and apart. Next, distribution policy is very important, obviously, to balance corporate needs with family stakeholder desires and wants. And needs. And one of the greatest needs over and above just cash flow is some sort of certainty. Family members are looking, they want to be able to plan their lives, particularly those who aren't as close to the business. So how do you do that? Can you express that through a formula or a guarantee? Well, guarantees can't be forever. As we've discovered in 2020, the fortunes of companies go up and down. This year, more rapidly maybe than in other years and through business cycles, but it just became much more apparent. So guarantees are kind of out the window. Can you work with a formula, or do you need to use some other approach? And again, it's all about managing expectations and competing goals. Next. Transfer restrictions, very common in shareholder agreements, but just to finish up, obviously within a family agreement, it can be very different. And in fact, this is one place where we tend to see things are actually more restrictive. You have narrower abilities or to deal with your shares. So there may be no concept of an individual right of first offer or right of first refusal. If somebody comes to you, an outsider, and offers to buy your share, there may be no exit. That would be very common for a family agreement. So what do you do about that? Well, next slide. First of all, you might have exceptions. One would be an allowance for spousal trusts, but spousal trusts, that's got to be looked at carefully as well, because some families feel strongly that the trustees of the spousal trust should have limitations on, should be limited as well. In other words, maybe just family members. Again, don't want to be dealing with your lawyers. Next slide. Employment, of course, employment can be a significant issue and can lead to discord. So bringing that out of, often it's covered in the vision or the value statement, bring that into the shareholder agreement itself, establishing a framework, seeing that there is a fair assessment. Often education, experience, abilities are covered or are referenced. And this is a place where independent board members can really play a role and remove that risk of family discord. Next, just circling back on liquidity to finish up, or almost finish up. I mentioned there might be no right of first offer, individual right of first offer, or individual right of first refusal. So how do you deal with that? Well, can you trade within the family? That's one, but that's a very limited, or leads to a very limited right. A strong distribution policy in lieu may assist, but only certain corporations are able to address it that way. Next. So you may have an ultimate exit provision. And again, there's no real formula here. If you have a family with 3 siblings, you might determine, or the family values might be, well, it's got to be, we need absolute unanimity. All 3 have to agree that there is going to be an exit. But other families feel no, 2/3 vote, 2 of the 3 really should be able to make that decision. And that's a decision that often should really be made by that generation, if I can put it that way. Move it into my example earlier of a generation with multiple, 16, 20, that becomes a little more tricky, and you probably want, if there's going to be a threshold, that number might be higher, and it might even need to have representatives from different branches of the family so that you don't have anyone dominating. Again, very different from a typical shareholders agreement. Next, second last, family law concerns should always be addressed. The need for domestic agreements and how or what will happen in the event of a marriage breakdown. Very typical. That does come up in a fair number of shareholder agreements, third-party shareholder agreements, but almost invariably should be addressed in a family shareholder agreement. Next, bringing back to some of the themes today that we've learned about in terms of privacy, dispute resolution. So I'm really drawing on things that Zohar, Daniel, and others were speaking about earlier, and Corina. Dispute resolution, if you are going to have agreements with family members, think carefully about public scrutiny. And there is a case to be made for private and confidential arbitration within a family context, or disputes or disagreements within families. Courts in Canada, of course, are an open forum, and there are lots of publications that make their business spreading the story about your families. So family wealth, ownership, the dynamics of families, other details are going to be open for the public to see and for people to report on. This can lead to embarrassment, privacy concerns, and ultimately even security concerns. So well worth going back to the extent you have agreements, go back and just think about whether dispute resolution has been addressed. Action plan, last slide. Thank you. Action plan for 2021. I would say assess your current circumstances, make a list of what matters to you, list what issues and themes you've heard today, the ones that might apply to you, seek advice from knowledgeable advisors, start the conversation within your family, and ultimately plan to put it in writing. Thank you. That's it.
Thanks, Doug. Thank you very much for that very detailed and thorough review of governance and family agreements. And I know on mandates we've worked together on, even just what the document is called has become important. And I know that's why you carefully use the phrase family agreement as opposed to shareholder agreement. I think there's a perception out there that getting one of these agreements is quite complicated. In your experience, sort of what's the one thing that you've seen actually work or has the better capacity to lead to a positive outcome for a family?
Well, good question. So there may be two questions in your question. First, complicated, and I hope my presentation didn't lead anyone to the conclusion that it is complicated, because as I said, that is a question we're often asked, and how can it be simplified? So ultimately, it's a family agreement or family shareholder agreement is about practical things, and they're about things every family thinks about. It's a little bit like the family cottage. How is it going to be used in the next generation? So these aren't complex issues. It's the only complexity might be in coming to a decision as to how you want to record it. In terms of the road to success, there are many paths to success, but I would say the one that is most important is taking that collaborative approach. So having that discussion generation to generation, and not the top-down imposition of, and we often deal with that, but the founder saying, this is my vision for not only the business, but the vision for the family. And that is important, and I don't mean to dismiss it, but the collaborative approach where, well, next generation, what do you want to do, and what do you see your role as, and what action might we need to take today to satisfy those desires, and put that in writing. That's really the road to success, using that collaborative approach. And I will say, as you know, Corina, most of the agreements we have worked on have been or have taken that approach, and they're actually enjoyable exercises. Families enjoy it. We enjoy helping with the guidance and bringing up the options. I've referenced a few of them today or posed them as questions. But as you get into it, some families come back, never thought of that before. Others, they already have a very firm understanding, and there's already agreement. There's already been the collaborative discussion, and it's a matter of just really recording it.
Thanks, Doug. And thank you, Dan. And I know Zohar had to jump. I want to thank our audience members. Sometimes this can be a bit of an awkward format because we can't see you and you get to see all of us. So I do hope you stuck with us through to the finish here and found the presentation useful. You will be receiving a feedback request, and we do welcome that feedback. And if you have any suggested things you'd like to hear us speak about, please do let us know that too, because we are looking to continue the mode of doing some of these presentations as 2021 rolls around. And all the best for the balance of the day and for the balance of 2020. Thank you very much for joining us. Bye-bye.